Hello everybody and welcome to this video which is on the sources of law in the English legal system. According to Bamford, Taylor and Valander, there are 5 main sources of law, which are custom law, case law, legislation, EU or European Union law and human rights law. The first source which I'm going to discuss is custom law. In order for a custom to be enforceable, people must have been carrying out that custom because it was something that they felt bound to do, and there was no element of force involved. Slapper and Kelly note that there are 7 requirements that need to be met before a local custom can be legally recognised. These 7 are: number 1, that the custom must have been in existence since time immemorial, which is usually held to mean since 1189. Now the problem here is that none of us were alive then, so in living memory tends to be used instead. Number 2 is that the custom must have been used on a consistent basis since 1189. Therefore, if evidence can be produced to show that the custom has not been in consistent use since 1189, then the claim of custom will fail. Number 3 is that there must not have been opposition to the custom. Number 4, the custom must have been felt by individuals to have been mandatory. There cannot have been an option whether to follow it or not. Number 5, the custom must be one which can be defined precisely. Number 6, the custom must not have been inconsistent with other customs that have been in use since 1189. Number 7, the custom must not be one which is unreasonable. Now this is quite an onerous test. Owing to this, Slapper and Kelly argue that custom is not now a key source of law. The second area to look at is case law. Now the doctrine of precedent or stare decisis, which literally means to stand by things decided, is seen to have great importance to the English legal system. What this term in both Latin and English means is that a decision of a higher court is binding on a lower court within that court structure. If a precedent has been set by a court that was of equal or higher status to the court in question, then the judge making the decision in the current case should follow what is termed the rule of law from the previous case. If the precedent is from a lower court, the judge does not have to follow it, but they can consider it. As Slapper and Kelly note, there are both advantages and disadvantages to the doctrine of stare decisis. Advantages include stability, reliability, effectiveness, flexibility, the ability to overrule, and the ability to distinguish between cases. However, the doctrine of precedent does have its disadvantages, and some of these are unpredictability, that the law may become fixed on a particular point, where the precedent is unjust, and that the doctrine of precedent is not constitutional because the judges are actually making law and not solely applying it. Let's have a quick look at legislation. Now this is the most important source of English law. Parliament is the main lawmaker in the English legal system. Parliament is made up of 3 elements: the House of Commons, which has 650 members who are directly elected; the House of Lords, which has 800 unelected members; and the monarch. Now let's have a look at the process which a bill goes through in order to become an Act of Parliament. The enactment process for a bill becoming an Act of Parliament is as follows. In the House of Commons you have the first reading. Now this is a formal stage where the title of the bill is read out and no resolution is needed. A date is then set for the second reading. You then have the second reading. This is the stage which sees the main discussion and debate of the bill's general principles. This is a key point in the bill's process. A vote is taken on the merits of the bill, and if the bill is approved, there is a good chance that it will become an Act of Parliament. The committee stage. The bill might be referred to the Committee of the Whole House or a private or public bill committee. The bill is then examined and any amendments are discussed. We then have the report stage. Now, if the above committees have made any amendments, then a report stage is needed. The House of Commons will vote on the amendments. The Speaker of the House of Commons can choose which amendments will be debated. Then we have the third reading, and this is when the amended bill is considered. It tends to be a short stage, which enables a final chance to vote, which is not often taken up. Then we go to the House of Lords. Now, these proceedings begin after the third reading in the House of Commons, and the same procedure is followed as for the House of Commons, with the exception that if any committee stages are needed, they will take place in the committee of the whole House. After the third reading in the House of Lords, if there are any amendments, then the bill has to go back to the House of Commons. A bill going back and forth is not uncommon, and this will happen until a bill is finalised. The final stage is royal assent. Now, when this is given, it is announced by the Speaker in the House of Commons and the Speaker in the House of Lords. Now let's turn to look at the court system. So the role of the courts in the English legal system is that judges firstly develop the common law and secondly interpret Acts of Parliament. So any appeals in English law always have to be on a point of law. We looked briefly in the previous video at the civil and criminal court structure, but the full court hierarchy is at the top. We have the Supreme Court. Now, this was formerly known as the House of Lords. The Supreme Court hears appeals on both civil and criminal law from the English courts and also Northern Ireland. It also hears appeals on civil law from Scotland. We have the Court of Appeal Criminal Division. Now, this hears appeals from criminal cases that had been heard in the Crown Court. The Civil Division is the civil version. The Civil Division of the Court of Appeal hears appeals on civil cases from both the High Court and the County Court. Now, below the Court of Appeal in the structure on the criminal side, we have the Crown Court, and this hears criminal trials and appeals in criminal cases that come from the Magistrates' Court. With regard to the Court of Appeal Civil Division, the court below that is the High Court. Now, this is split into three courts. You've got the Family Divisional Court, the Administrative Court. Now, this used to be called the QBD or Queen's Bench Division, and then we've got the Chancery Divisional Court. The Family Divisional Court hears appeals on family issues from the County Court. The Administrative Court hears judicial review cases and appeals on some criminal cases as well. The Chancery Divisional Court hears appeals regarding cases that concern land and tax from the County Court. Looking at the court structure, criminal, below the Crown Court we have the Magistrates' Court. Now, this hears family cases regarding non-payment of debt and also criminal trials. When we look at the civil side, we can see there's the county courts. Now, a county court hears civil cases, and this depends on the value of the claim though, and it hears family cases. There are also tribunals. Now, these hear appeals regarding immigration, child support, social security and pensions. Let's turn to look now at European Union legislation as a source of law. Now, although the UK has left the European Union legislation still has an impact upon English law. Any EU legislation which was in force before 11 p.m. on the 31st of December 2020 has been kept in UK law and retained as EU legislation. Now, this is from the European Union Withdrawal Act 2018. However, this legislation is now known as domestic legislation. The final area to look at regarding the sources of law is human rights law. Now, the European Convention on Human Rights entered into English domestic law via the Human Rights Act 1998, which came into force in October 2000. The 1998 Human Rights Act does not enable the courts to make primary legislation invalid or set it aside. It is only the executive, Parliament, that can amend laws. Please see these slides of references, both of books used and statutes stated in this video. There are also going to be 2 free PDFs available. One is of the court structure and the other is of the process for a bill proceeding through Parliament and the Lords and gaining royal assent. If you would like a copy of these PDFs, please click the link and we will send a copy of these PDFs to you for free. Thank you for watching. Bye bye.